Hello, my name is Ankit Yadav. I am an advocate and I work primarily at the Supreme Court of India. Today, I would be talking about the Terror and Constitutions module under the Comparative Constitutional Law course. While doing so, I would be talking about three jurisdictions, namely India, United States and the United Kingdom. Now I'll start with giving you a brief introduction about the topic and how it is relevant today. The concept of terrorism has existed in various forms since the beginning of the civilization. However, only towards the end of the 20th century and early 21st century, it got recognized as the most imminent threat to the peace and security of the world. Now, there have been several attempts to define the word terrorism, but some say that we are yet to reach a comprehensive definition. This is principally because states are reluctant to adopt a legally binding definition due to political considerations and many other considerations. The United Nations General Assembly gave us one of the widely recognized definitions of terrorism in the following terms, and I quote, "Criminal acts intended or calculated to provoke a state of terror in general public, a group of persons or particular persons for political purposes are in any circumstance unjustifiable, whatever the considerations of a political, philosophical, ideological, racial, ethnic, religious or any other nature that may be invoked to justify them." These acts today are challenging the authority and existence of even the most powerful of the nations. Modern day terrorism seeks to achieve various political as well as ideological goals. The financial resources and sophisticated weaponry available to the terrorist organizations is dumbfounding. The challenge before the legislatures of the world is to balance the integrity and security of the states while protecting the human rights and rule of law. Legislations that allow unwarranted incursions into human rights in order to prevent terrorist activities violate the basic tenet of any democracy, that is, the rule of law. Now let's take examples from three different jurisdictions, India, United States and United Kingdom, to see the relationship between terror and the constitution of these countries. Starting with India, India has enacted several legislations to curb terrorist activities. The power of Parliament to enact such laws flows from the entry 1 of the Union list in the 7th schedule of the Constitution of India. It relates to the defence of India and entry 97 that provides that the Union will have all the residuary powers. Now, in Kartar Singh versus the Union of India, the Supreme Court categorically held that, having regard to the limitation placed by Article 245, Subclause 1 on the legislative power of the legislature of the state in the matter of enactment of laws having application within territorial limits of the state only, the ambit of the field of legislation with respect of public order under entry 1 of the state list has to be confined to disorders of lesser gravity having an impact within the boundaries of the state. Activities of a more serious nature which can threaten the security and integrity of the country as a whole would not be within the legislative field assigned to the states under entry 1 of the state list, but would fall within the ambit of entry 1 of the Union list relating to defence of the country, and in any event under the residuary powers conferred on the Parliament under Article 248 read with entry 97 of the Union list. The Parliament thereby has the power to enact such legislations to protect the sovereignty and integrity of the nation against all threats. However, such legislations and their ability to impinge upon the fundamental rights has always raised a debate of constitutionality of such legislations. Now let's see some legislations that have been enacted by the Parliament to counter terrorist activities and which have been tested time and again on the touchstone of the Constitution of India. Starting with the Unlawful Assemblies Prevention Act 1967, which is more popularly known as the UAPA, this was an act aimed to deal with such activities and associations that may constitute threat to the territorial integrity of the nation. During the parliamentary debate for this law, numerous legislators asserted that its sphere of application should be limited to avoid any kind of conflict with the rights of association. So, the ambit of the statute was strictly limited to meeting the challenge of threats to the territorial integrity of India. The legislation was an exhaustive code in itself for declaring secessionist associations as unlawful, adjudication by a tribunal, control of funds, and places of work of unlawful associations. The Act has all along been worked holistically as such and is completely within the purview of the Union list in the 7th schedule of the Constitution. However, with the rise in terrorist activities, a need was felt to enact even more stringent laws to effectively deal with the situation. The Government of India was facing extreme criticism for its inefficiency in handling the Mumbai attacks. Therefore, the law was comprehensively amended by the Unlawful Assemblies Prevention Amendment Act in the year 2008, which was to deal with terrorist activities. The Act was supposed to balance the need to combat terrorism and the right of people to civil liberties, and to give teeth to the provisions of the earlier UAPA. However, it was said that the Unlawful Assemblies Prevention Act was amended in a haste without adequate debate, and also that the essence incorporated those provisions that became source of misuse of anti-terror legislations. There is a provision in the amended law that is supposed to check its misuse, as every prosecution has to be first sanctioned by an independent authority that will review the evidences before making a final decision. But this authority is appointed by the government that raises serious concern about its independence and the possibility of it being a mere rubber stamp for political actions. There is definitely a need to prevent and punish terrorist attacks by having more effective laws and the enforcement as well. However, merely enacting a stricter law would not solve the problem, especially when there are no effective ways of keeping a check on the misuse. The second key legislation that came into force in 1985 was the Terrorist and Disruptive Practices Act 1985. It was modified in the year 1987 and it had much more rigorous provisions than the previous UAPA and was specifically designed to deal with terrorist activities within India. It created two new offences, namely terrorist acts and disruptive activities. It also imposed restrictions on the grant of bail. According to Section 20, Subclause 8, bail could be granted only when the court was satisfied that there were reasonable grounds of believing that the accused was not guilty. This provision actually reversed the presumption of innocence that is embodied within our criminal law jurisprudence. Trials under the Act were to be given precedence over other cases. Also, the police were given enhanced power of detention. They could detain a person for up to 1 year without initiating any trial. Under Section 15, certain confessions made to the police officers not below the rank of Superintendent of Police could be taken into consideration as an evidence. This provision contravened Section 25 and Section 26 of the Indian Evidence Act that makes confession by the accused before the police officer inadmissible as evidence. However, because of its sweeping powers, it was challenged before the Supreme Court of India as being unconstitutional. In the case of Kartar Singh versus the state of Punjab, the Supreme Court of India upheld the constitutional validity of the Act, stating that those entrusted with such stringent statutory powers would act in good faith and for public good. The court rejected the contention that Section 3 and Section 4 of this Act were unconstitutional. It opined that provisions for separate trial machinery does not amount to discrimination under Article 14 of the Constitution. The stringent provisions and speedy disposal mechanism that depart from the procedure prescribed under ordinary procedural law was considered necessary due to inadequacy of the prevalent ordinary law. Section 5 of this Act penalized possession of arms in notified areas. This resulted in prosecution of man solely for possession of such arms or ammunition, irrespective of any association with terrorist groups or activities. Therefore, the court held that this section is harsh and should be invoked only when the person in possession of such arms can be associated with a group or organization. However, there were several instances of misuse for collateral purposes. The stringent provisions of the statute came to be abused in the hands of law enforcement agencies. Therefore, as a result of all these controversies, this Act lapsed in the year 1995. Then came the third legislation. The Union Cabinet of India issued the Prevention of Terrorism Ordinance in October 2001. It granted sweeping powers to the state law enforcement agencies and most notably targeted those who allegedly incited, supported, abetted, harbored, concealed or benefited from the proceeds of terrorism. On December 13, 2001, terrorists allegedly backed by Pakistan attacked the Indian Parliament in a failed attempt to assassinate the legislators. And 3 months later, during a rare joint session convened at the request of the Prime Minister, the Prevention of Terrorism Act was enacted as a statute. Soon after the legislation was enacted, several human rights groups and Indian media reported numerous cases on misuse of POTA, which is the Prevention of Terrorism Act. Its constitutional validity was challenged in PUCL versus Union of India, where the Supreme Court in its judgment remarked that protection and promotion of human rights under the rule of law is a necessary concomitant to preventing terrorism. The court concluded that, and I quote, Parliament has explored the possibility of employing the existing laws to tackle terrorism and arrived at the conclusion that the existing laws are not capable. It is also clear that terrorism is not a usual law and order problem. The constitutional validity of POTA was upheld. However, certain safeguards were introduced, such as mens rea was made a sine qua non for the offences for abetting terrorist activities under Section 3 of that Act. Section 4 of the Act provided for punishing a person in custody of unauthorized arms. The court interpreted is as being in conscious possession of those unauthorized arms. However, despite such measure, there were complaints that the state law enforcement agencies were misusing the provisions of this Act. There were numerous instances of arrests and detentions without formal charges being filed. Although special courts were constituted for expedition of the process, they did little to counter POTA's permissive stance on such lengthy incarcerations. Some of these problems stemmed from law's broad text, while others were rooted just in its enforcement. Consequently, soon after the new government was elected at the center, POTA was also repealed. Now let's carry our discussion to the scenario in the United States. The American legal system has traditionally, and especially in the academic works, been a strong proponent of civil liberties. Respect for the rights of the accused and presumption of innocence have been of primary importance. The Constitution of the United States itself embodies the respect for human rights and the concept of a democratic and just nation. However, today, with a change in the global scenario and with the United States being at the forefront of the war on terror, there have been widespread allegations of violations of civil rights by the same American law enforcement agencies which were constituted to protect the society. The war on terrorism has given the government enough reasons to justify wide-ranging expansions in the powers of the federal agencies that seriously undermine the civil liberties granted by the American Constitution and the customs followed by it. In the year 1995, after the Oklahoma City bombing, the United States passed a controversial anti-terrorism legislation. It was titled Anti-Terrorism and Effective Death Penalty Act 1996, which was popularly known as the AEDPA. It, among other things, allowed the federal government to freeze assets of organizations designated by the Secretary of State as a terrorist organization. It also restricted the right to review for the convicts to challenge their conviction or terms of detention. After the 9/11 attacks, the United States enacted the United and Strengthening America by providing appropriate tools required to intercept and obstruct Terrorism Act 2001, which was more popularly known as the Patriot Act. This act permits the sharing of grand jury information between law enforcement agencies, intelligence groups, and such other agencies, even without a court order, and this amends Section 6E of the Federal Rule of Criminal Procedure in that regard. It also empowers the investigative agencies to use phone taps as evidence. It has stringent provisions to counter terrorist threats. It also eliminates the need for a search warrant for voicemail messages more than 180 days old. It also adds terrorism crimes, offences related to biochemical weapons and attacks, computer fraud, money laundering, and a variety of other crimes for which wire, voice, electronic or oral communications are subject to legitimate interception and for which a warrant can be ordered. It is evident that the executive and legislative branches of the government have used the fear of terrorism and increased emphasis on the effective crime control to adopt policies that would earlier have been considered abhorrent by the American civil rights activists. Suspension of habeas corpus for suspected terrorists, search without warrants, monitoring of mail and electronic communications, and coercive interrogative practices, all of them which were prohibited by the American Constitution, are now considered as valid and justifiable exceptions in the traditional legal standards, traditional legal standards. It has been asserted that the new anti-terrorism legislation has done little to ensure national security and much to compromise on the nation's standards. Therefore, the United Nations legal system faces a predicament where its own legislations are apparently locking horns with the time-honored constitutional safeguards, especially the ones against illegal search and seizure and illegal detention. Coming to the judgments of the courts in the United States, in Hani Mahmood Kiar Deen versus Renault and Immigration and Naturalization Service, a federal district court of New Jersey upheld the constitutionally guaranteed rights of a person guaranteed by the Fifth Amendment to the Constitution of the United States against AEDPA. While delivering the such judgment, Judge Walz opined that, and I quote, "Here the government's reliance on secret evidence violates the due process protections that the Constitution directs must be extended to all persons within the United States, citizens and resident aliens alike. The INS, that is the Immigration and Naturalization Service, procures patently failed the INS procedures patently failed the Matthews test of constitutional sufficiency, and the court finds this failure to be sufficient basis to grant the petitioner's writ for habeas corpus and direct his release from the custody." In another case dealing with the AEDPA, titled as National Council of Resistance of Iran versus Department of State, the US Court of Appeals for the Third Circuit has held that two organizations, the National Council of Resistance of Iran and the People's Mujahideen of Iran, petitioned for review of the Secretary's designation of the two as constituting a foreign terrorist organization under the AEDPA. raising both statutory and constitutional arguments. While we determine that the designation was in compliance with the statute, we further determine that the designation does violate the due process rights of the petitioners under the Fifth Amendment, and we therefore remand the case for further proceedings consistent with this opinion. Further, even after coming into force of the Patriot Act, the United States Supreme Court has upheld the constitutionally guaranteed rights of the people against any executive action that raises any conflicting situation. Now let's move on to the legal framework in the United Kingdom. Even though the British Constitution is an unwritten constitution, it has undergone a very long period of changes, catching up with the changes in the societal norms. Various legislations have given it the nature it has today, and one of the most significant one for the present discourse is the Human Rights Act 1998, which statutorily force to a large number of which brings into force a large number of internationally recognized human rights. The United Kingdom follows a system of parliamentary supremacy, which means no person or body is recognized by the law of England as having a right to override or set aside the legislation made by a parliament. However, taking into consideration the mood of the public at large, the legislature could never take away any human right. Further, the courts have been, even if to a limited extent, exercising judicial review over the legislative and executive actions. As a response to the 9/11 attacks in the United States, the Parliament of the United Kingdom enacted the Anti-Terrorism, Crime and Security Act 2001. The said act clearly reflected the atmosphere of fear prevailing at that time, especially when we take into consideration the fact that it contains provisions for indefinite detention of an accused without any charge or trial. Also, it is pertinent to note that Section 21 subclause 1 of the said act empowered the Home Secretary, which is an executive, to issue a certificate in respect of any person if the Secretary reasonably believes that the person's presence in the United Kingdom is a risk to national security and also suspects that that person is a terrorist. Further, a combined reading of sections 22 and 23 provides that such a person may be detained if cannot be deported because of laws relating to any international agreement or because of any political considerations. In A versus Secretary of State for the Home Department, the House of Lords was faced with the question whether said act meets the conditions prescribed under Article 15, which provides for derogation from the European Convention on Human Rights from time to time in cases of emergency. While delivering one of the most significant judgments of recent times on the subject, the House of Lords held that the act fails to satisfy Article 15 and that the provisions of indefinite detention are inconsistent with Articles 5 and 14 of the European Convention on Human Rights. Lord Hoffman strongly expressed his opinion in the following words: "Such a power in any form is not compatible with our Constitution. The real threat to life of the nation in the sense of a people living in accordance with the traditional laws and political values comes not from terrorism but from laws such as these. That is the true measure of what terrorism may achieve. It is for Parliament to decide whether to give terrorists such a victory or not." After such a strong reaction from the House of Lords, the British Parliament was practically forced to change the legal framework by enacting a new legislation titled as the Prevention of Terrorism Act 2005. This act replaced the earlier regime, and the Home Secretary was required to obtain permission from the court prior to detain any person except in urgent cases. Also, the individuals were given an opportunity to appeal against such an order before the Home Secretary. Therefore, it is quite evident that even though the courts in United Kingdom, are not empowered to strike down a legislation, their judgments are something that cannot be ignored by the Parliament or the executive. The legislatures could have refused to pay any heed to the court or to the House of Lords judgment, justifying it inter alia on the grounds of national security. However, they reacted by changing the legal framework, adopting a more protective approach towards the civil rights of the people. Now, to conclude, I would like to say that the most vital question that the anti-terrorism legislations raise is what should be the extent of intrusion on constitutionally guaranteed rights. Is a society where national security given precedence over constitutionally guaranteed rights and civil liberties a more secure society than a just society? Or should the civil liberties be protected at all costs? Compelling public interest argument is forwarded to justify a blurring line between the legitimacy of such infringement and excess of the same. However, it is essential to understand that public interest is not necessarily defined by national security. It has been seen that strict anti-terrorism legislations often violate the rights and liberties of the innocent. Since terrorism is an attack on the government institutions, it is necessary that the government exercises restraint in shedding constitutionalism behind the garb of national security. The governments should exercise extreme caution because unwarranted incursions of civil liberties inevitably leads to anti-government sentiments which impediments the fight against terrorist activities. Thank you. I hope that this discussion was interesting for you and it was helpful.